Folks, what I'm going to talk to you today about is what to expect in a criminal trial if in fact you end up going that far within the criminal justice system. We're going to divide this into two parts because there's a lot of stuff going on. Keep in mind, everything prior to the trial is your lawyer, myself, working the case up, trying to discover all the facts in terms of the evidence that the state has, the background of the witnesses, what to expect at trial, and always try to stay a step ahead of them. Part of that pretrial effort is to actually interview prior to trial, which you have the right to do, interview the witnesses. You do not, under Arizona law, under the Arizona Constitution, have a right to interview any alleged victims in the alleged crime that you've committed. So you can't do that, but all the witnesses, lay witnesses if you will, or police officers, things like that, you can interview. So if somebody is, let's say, the victim of an aggravated assault or an armed robbery, because you supposedly pointed a gun at them and demanded money, that person is, you can ask to interview that person, but they can respectfully decline, and the prosecutors will always tell them, hey, you don't have to do this, so don't do it. And that's what we jump through all these hoops. So I'm preparing, I go through the police reports, I end up maybe filing some pretrial motions to narrow the issues of the trial. So instead of the trial being this big once you get to trial, it's this big. You might move to preclude some physical evidence because it hasn't met certain standards of testing. You might wish to preclude some witnesses for whatever reason. They're biased, if you can prove that, or some of your constitutional rights have been violated. You might try to preclude a search as being improper without a search warrant, or that the search warrant that was gathered by the police officers or any kind of law enforcement was somehow invalid because of an affidavit that contained facts that weren't true, in other words, a lie. So you narrow the issues down, and then you walk into court the morning of trial, and you have 40, 50, 60 people in there. You get a list of these people. You start going over them to see if any of the names ring a bell. Let's assume they don't. And then you get little tiny pieces of paper that are about this big or so, and it has some background information. It's got the person's name, the city in which they live in, maybe the crossroads, because you don't have a physical address, male or female, college education or how far the person has reached in college, last grade completed, I believe is the actual term that is used on most of the slips, whether they have any prior felony convictions, because that would actually preclude them from being a juror. So you take these documents and you try to learn as much as you can, and then you go through a process called voir dire, which is where both the, I should say both, but three, the court, the judge, myself, and the prosecutor ask questions of the prospective jurors. And then there may be some you have a gut feeling of that you don't like, so that's called a strike, and you strike them. You might end up striking them for cause, meaning the person has flat out said anybody accused of a DUI or has been drinking and driving is guilty of a DUI. And that's not the law. And then the judge will try to help them a little bit by saying, well, if I tell you the law is that it's not illegal to drink and drive, but drink and be impaired to drive to the slightest degree, and the person says, well, I don't care. If you drink and you drive, you deserve what you're going to get, then that person would be excluded or struck as being biased and not listening to the instructions of the judge. And typically, both the state and myself don't want people like that. We want people that are sitting on the fence so that you get a fair trial and we don't have issues down the road. So what happens is the misnomer or the statement that you pick a jury, which is what everybody says, you really don't pick them. You get rid of who you don't want, and then depending on what court you're in, whether it's city court or justice court or superior court, you take the first 6 that are available to you on the list, because everybody's got a number, or 8 or 10 or 12, and then usually pick 1 or 2 alternates, meaning if one of the jurors, and the alternate, by the way, is picked after the trial is over, literally out of a hat, out of a hat, a number, and then that person is the alternate. And they go home, and they wait for a phone call that may never occur, because let's say the remaining jurors that ended up deliberating or deciding for you or against you, one of them gets sick or gets into a car accident or something and they can't make it to court to continue to deliberate, that person, the alternate, gets called, come back in, and they start from scratch again. So anyhow, what happens is, you're at trial, you go through this jury process, jury selection it's called, and then whatever's left over after you struck the people for either cause or not is, depending on the number again, the first, let's say 6 people, let's call it city court. And in city court you have 6 jurors, and the first six people is who becomes the jury. They get sworn in, And then the state, because it's their obligation to prove you guilty beyond a reasonable doubt, and they have the burden, they always have the burden of proving you guilty beyond a reasonable doubt. I mean, conceivably, it's said that you and me as your defense attorney don't even have to be there because you don't have to put on any evidence. There's no requirement that you put on evidence to prove yourself not guilty. That's not what you're there for. And really what I'm there for is to make sure everybody plays fair, and then to try to attack their witnesses as being untruthful. They couldn't have seen it where they were standing at, they were potentially biased, whatever. There's just ways of cross-examining those witnesses so that you can discount their testimony as being really nothing. And eyewitness testimony, by the way, has been found in multiple studies as being the worst testimony possible. Except, of course, if it's a police officer testifying, then jurors tend to believe police officers more than they do normal citizens. So, in any event, you have your jury, they're impaneled, so they're sitting behind the wall, if you will, sitting all by themselves. And then the state puts on an opening statement, and they give an overview of, is the best way to put it, an overview of what the jurors can expect in the trial. And sometimes, just like in a card game, you don't want to show your hand right away. So I typically don't do that. I'm very brief. I'm not going to tell them, gee, my witness, Joe Blow, is going to come in and completely contradict the police officer or anything else, unless there's no downside to me telling them that. And the prosecutor, by the way, is listening to this, so I don't want to give away what cards I'm holding in my hand yet. And the prosecutor had the right, and does have the right, to interview all of my witnesses prior to trial, too. It goes both ways. And by the way, we have full open disclosure in Arizona, and that theoretically means that any of the evidence and the background information of police officers, if it's bad, or lay witnesses, has to be laid out on the table for you and me to look at. It's full disclosure. There's no Perry Mason episodes where some surprise witness walks into the courtroom to save somebody. That doesn't happen. That was TV years ago. So, in any event, the prosecutor does their opening statement, then I get my chance, and as I said, my way of strategy is make it super brief, and then the prosecutor calls their first witness. And the judge, or the bailiff, swears the person in, and the first witness could be a lay witness, and let's assume it's an armed robbery, like I said before, and this happens to be the victim. So I only know what the testimony is going to be based upon the police report that I've read prior to that, because remember, typically I'm not allowed to interview the victim, and the state is telling, or the government's telling that victim, yeah, you don't have to give into a pretrial interview, so you probably shouldn't, because they make it sound like I'm going to harass them during the pretrial interview. It's not the case, but it used to be where I was allowed to do that, not anymore. In any event, that person gets up there and testifies. I cross-examine that person. Let's assume they have a different story. They give a description of the alleged bad guy, if you will, who pointed a gun in their face, and they say on the stand the person had blonde hair and blue eyes. And the police report says black hair and super brown eyes. Well, there's a point I can bring up during my cross-examination, because when the state is done with that witness, I get to cross-examine them. It's my turn to ask the questions, and I can go all over the place, essentially. Cross-examination doesn't have to be as focused as direct examination. Plus, I can lead a witness into a little path that I want them to go down, but somebody that I call as a witness when it's defense turn, or the state cannot lead a witness. They have to ask direct questions, and then they get direct answers. Sometimes witnesses will waffle a little bit, not answer. Sometimes you have to direct or ask the judge to direct the witness to respond to you. I mean, all sorts of strange things can go on because I've seen it happen. I once had a trial where a witness was a victim in a domestic violence case that kept spinning her chair away from me so she didn't have to look at me. I finally had to instruct the court, ask the court for an instruction to her to tell her to face me and quit swiveling her chair around. It was really bizarre. The fun thing about trials, at least for me, is that you have to learn how to deal with unexpected things, learn how to shoot from the hip. I enjoy doing it. You have to think quickly on your feet. So then the state gets done with their witnesses. They put their case on. Now, I can stand up and say, we don't have anything. I'm not bringing in a witness. My client has chosen not to testify, and I'm not doing this with the jury present. The jury's back in their room. But the state's done with their case. And let's assume that my client, and it's his choice, or her choice, wants to testify. They want to tell their side of the story. Hey, I was at a movie that night. I couldn't have been the armed robber. Or I've got brown hair, or I've got brown eyes, or whatever it happens to be. But it's their choice. It's not mine. They make their decision with my advice, but I don't have to bring in other witnesses to defend this case, if you will, and try to prove them wrong. Hopefully my cross-examination has fully attacked their testimony to the point where the jury looks at them and go, we don't believe any of this. And that's the key. They don't believe it, or there's some doubt that's thrown onto the credibility of those witnesses or the physical evidence, maybe a video, maybe a photograph, things are taken out of context. In part two, I'm going to tell you what the defense does and how the trial ends up ending. And I'm simplifying this so you can get a good understanding of how this thing will go on a criminal trial and what to expect if you end up deciding to go to trial instead of taking maybe a deal that the state has put on the table, or in fact, the deal is so bad you just want to go to trial and roll the dice, or maybe you didn't do it. My job is not to get you off, contrary to what people have repeatedly said in comments to my videos. My job is to make sure that you and everybody else, my family, your family, everybody plays fairly and you get a fair trial, because that's the way our system works. That's my job, and it will always be my job. Thank you.
This posted video is in no way specific legal advice on any subject. It is intended to provide general information for the public. If you need specific legal advice, call Chuck at 480-545-0700.
If you have any questions or ideas for these video topics, please email me at lawyer@chuckfranklin.com. That's lawyer@chuckfranklin.com. And I'll consider your topic, and maybe you'll see yourself on my video channel. Thank you.